Welcome. My name is Katina Michael. I'm from Arizona State University, and I'm here with my PhD student, almost Dr. David Kolevski, almost, a few weeks to go, I think, before minor changes are submitted. David, welcome.
Thank you. Thank you very much for having me. It's been a pleasure working with you for the most part of a decade. It's been an exciting and very exciting journey, and I've enjoyed all of our challenges and obstacles.
Me too, because we've turned them into opportunities. And together with Dr. Robert Abbas from the University of Wollongong and Dr. Mark Freeman from the same institution, one in the School of Business, the other in the School of Computing and Information Technology, we've really seen some dramatic changes in cloud computing. Firstly, the introduction of widespread cloud computing services, and then these security breaches, these data breaches, this heightened awareness of what, personal information and it's hacking is all about.
Yes, yeah, we've seen a very dramatic increase from the innovation point of view, as well as from adoption. We've seen all aspects of everyday services being adopted and being transformed by the cloud, and we are going to continue to see this transformation occurring. And as a result of more consumers, of more everyday users using clouds, we'll likely see a lot more data breaches occurring.
So your thesis is pretty timely as a result. I know you concocted this, I think it was in the late 2000s, if I'm not mistaken. And by the time you had finished your master's degree and we had done advanced business process management together, you had a clear idea of what you wanted to do. But what was that trigger that said I should do a PhD in this area?
I believe early on my career, I've seen and witnessed and experienced firsthand what computer hacking can do to a business, as well as to its consumers, and that really triggered my thought on what will happen in the future. It's just been such a dramatic and such an increase of use of online services. And I think the most interesting point is that end users, most of the time, don't even know that they're using cloud services. And I feel that that's a topic in itself. I feel really passionate about discussing these ideas that I have.
Well, we just heard you present at UEMGreen, a conference in India dedicated to many aspects of cloud computing and artificial intelligence. All of these areas are fusing now, and we saw some incredible presentations by local Indians, quite technical presentations. And this one was a bit different. It touched on regulation and data breaches, but I really wanted to give you more time. I know, in conferences, you're often hard pressed for time and presentation time and Q&A, but take us through this. I'm going to go on mute and I'm going to hide myself. And I just want you to enjoy going through this presentation pack. I think there's a lot there to unpack.
Thank you. And I definitely will enjoy this. Okay, so as Katina has mentioned, I am a PhD student, and my research does focus predominantly on cloud computing data breaches. And the most fascinating point of this research paper is, in fact, that it's focusing just on a tiny aspect of my research. The paper focuses on a review of US regulation and data breach notification literature. And the main focus of the paper is to review existing literature and to view how cloud networks are being regulated from a privacy and security point of view, but then at the same time, it also focuses on, well, how are the end users notified? So I'll begin by outlining the presentation. The paper focused on 5 key aspects. First, I'll dive into the stakeholders in a cloud value chain. This is an area that is definitely undervalued in such that it just focuses on a high level representation, where I intend to go a bit deeper to explain the relationships between the stakeholders and how one stakeholder does directly impact another. I then review from a high level perspective cloud computing data breach literature. I also review US cloud regulation and DBMs. But importantly, I present 3 notable data breach cases. That's the 2011 Sony PlayStation data breach, as well as the 2015 Anthem healthcare data breach, and last of all, the 2017 Equifax data breach. And to conclude the presentation, I will focus on key outcomes as well as future research on the potential of cloud regulation as well as DBMs. Okay, so what we have in the literature is a very undervalued cloud value chain. It predominantly focuses on the cloud provider as well as the cloud customer, but it underappreciates the end users, the everyday consumers of the cloud service. So what we have basically is 2 sets of stakeholders. We have operational stakeholders, and they tend to focus on the technical aspects of the technology. So you have the providers, the customers, the enablers, the resellers, as well as third-party providers. But then you have your non-operational stakeholders, which focus on how the technology is governed, how it's regulated, and other stakeholders such as law enforcement and industry standard bodies also factor in how the technology is being used and applied. Now, importantly, the end users in this cloud value chain diagram is located as a non-operational stakeholder, and that's due to the fact that they don't provide any technology input from the literature review. So what constitutes a cloud computing data breach? So what is a data breach? Well, we can say that a data breach is when data is stolen or misappropriated. So when a computer hacker or a cyber criminal group illicitly take that data and then misuse that. So why does this occur? So the most important thing to understand is that a data breach typically occurs because insufficient or outdated security defenses are applied. But then also we have to factor in that the social implication of the technology itself, such as improper employee training. So this typically results in computer and network crime abuses, which in most cases, if not in all cases, there is definitely a delay in data breach reporting to the affected stakeholders. Now, the most important thing is to understand that the disclosure of personally identifiable information, financial information, as well as healthcare and geolocation data, as well as numerous other types of data can be disclosed. So why is cloud computing regulation important? So why do we need that? And why is it misrepresented in the literature? So we have to focus on a high-level environmental issue, and that typically targets cloud regulation. However, other studies also typically integrate or coincide with privacy implications. However, there is an urgent need of transformation to better protect cloud end users. However, not all studies determine that cloud regulation is necessary. Privacy and security should not be a direct consequence for the loss of innovation. However, it's important to know and to understand that regulating emerging technologies is difficult, it's challenging for all stakeholders within that value chain, and as such, and can be applied to the cloud computing value chain. So why do we need to regulate emerging technologies, as well as the need for it? So there needs to be a balanced approach between reg and innovation. Existing regulation on emerging technology should be revisited. And a study by Jager Lynn Grimes, as well as was in 2008, quite an early study in cloud computing. However, the principles of that study still apply today. So the privacy, the security, the reliability of that service, policy and regulation are all intertwined. So now we focus on US data privacy regulations. So the literature focused on three main data privacy regulations. First is the US Health Insurance Portability and Accountability Act of 1996, which focused on a federal health regulation approach. The main intention was to provide adequate, safe, and easily accessible health information to be stored and transferred in electronic form. The second data privacy focused on Graham-Leach-Bailey Act of 1999, and that focused on providing a federal financial regulation approach to safeguard unsolicited financial information sharing between stakeholders. However, the US Stored Communications Act, which was initially designed and developed in the late 80s and 90s, was initially intended to expand the Fourth Amendment. However, applying existing regulations will not support clouds. Regulation is outdated for technologies used today, and as such, there is an urgent need of reviewing, especially the Stored Communications Act. So what is the main pitfall of US cloud regulation? So the literature focused on industry related. So here we talk about silos between industries, so healthcare, financials, and there's no universal or federal cloud regulation approach. And as such, there's a failure to incorporate regulation with society, technology, and environmental needs. As a result, this has directly impacted and increased the number of cloud data breaches. As of 2021, we have seen numerous data breaches, such as the Facebook data breach that has disclosed more than 500 million end user records, and the recent LinkedIn breach, which has also disclosed more than 500 million end user records. So the literature focused on band-aid fixes to hacking of cloud services. Stakeholders, including end users, are in no better position than before. Now we turn our focus on data breach implications. What is data breach implication? Well, data breach implication is simply a notification process that is applied by the business affected by a data breach to its affected end users. That its main responsibility is to notify its users. However, the US has a mixed approach. It focuses largely and predominantly on the state-based notification process. However, using this approach, it's insufficient as cloud providers and customers operate over diverse boundaries. They often pass responsibilities down the value chain. It's important to understand and to know that cloud providers are basically passing the buck down the stream to cloud customers and eventually to end users. And the main and preferred option in response to protecting end users is basically credit freezing. The first of 3 data breach cases that I'll be talking about today is the 2011 Sony PlayStation data breach. It affected more than 75 million end users. Names, dates of birth, physical addresses, email addresses, as such, were disclosed in that breach. However, it was the first such breach that occurred on a cloud platform that basically their corporation shut down the gaming network and gradually restoring its services over several weeks. However, an important study by Boner, 2018, states that Sony did not initially inform end user about the data breach. In fact, they delayed notifying its end users by more than 3 weeks. So why did the data breach occur? Why can a large multinational organization that operates in numerous national and international jurisdictions, how can, with such a large employee base, how can they be hacked? And this is one of the most fascinating data breaches that I've come across professionally and academically. It was down to human and technology errors. So in fact, what the literature is saying is true, it's valid. Social and technical implications are direct results from and leading to data breaches. However, the most important topic to think about is the long-term implications of this data being disclosed. So what actually happens to the end user's PII in this circumstance? Studies have shown that there are potential for identity theft. The 2015 Anthem healthcare data breach was one of the most significant healthcare data breaches in its time. And in 2021, it still remains one of the most important data breaches, as it directly affected more than 80 million customers, and it disclosed names, addresses, social security numbers, as well as healthcare information. So once again, how can a large national organization be susceptible to hacking? How can they be breached? Well, advanced and customized hacking techniques were a direct result for the data breach. But why are healthcare records so lucrative to cyber criminals? Basically, they have a higher value rate on the black market. However, monitoring systems were slow to detect the system. So we can say that employee and technology systems failed. However, they did notify its customers, or in this case, its end users within 7 days. However, it's still delayed its notification. Now, the 2017 Equifax data breach was a very fascinating data breach, because ironically, they are a credit bureau providing identity theft protection. Now, in this circumstance, over 145 million customers were affected. It disclosed names, addresses, social security numbers. Most of the customers did did not even know they were customers of Equifax. They didn't even know that they were or how the data being collected by the corporation. So what happened here? So how can a large national, international organization be so susceptible to such a hacking event? Well, a known vulnerability in 2017 was Apache Struts server software, and this was not this was not patched by Equifax, and as such, hackers were able to enter the corporate cloud network. So once again, we can see that interrelated and a dependent human error along with technology vulnerability. Equifax notified its customers several weeks after the initial discovery. However, ironically, Equifax did create a website to notify the public. The link directed many to a hoax website. And finally, the company itself offered free credit monitoring. So what we have here, we have noted that current regulation is inadequate for cloud computing services. We have seen that the US context displays state-based I've also seen that the US context displays individualized as well as state-based DBM approach. We've also seen that data breach cases are on the rise, especially cloud-based services. We have seen it's important and it's vitally important to revisit existing cases. Existing cases not only tell us what has happened, but where we will be heading into the future. And the Sony PSN, Anthem Healthcare, and Equifax breaches show human and technology vulnerabilities do play a part. So where does this leave my research? Well, more research into the social technical implications of cloud data breaches. Some of the questions might arise: could bridging the gap between the human and technology reduce data breaches? Could financial compensation be resolved by the courts? Are end users reimbursed from the stolen financials? Can that be a way to compensate? However, the most pressing issue is what actually happens to that identity information once it's been disclosed. Could identity information be recovered? These are some of the questions that are coming out of the literature. So now we conclude this short research paper. So this research has only scratched the surface concerning US cloud regulation. And it's only the tip of the iceberg concerning data breach implications. While the environment is an important dimension in this aspect, the social and technical dimensions are equally as important. The use of outdated regulation on emerging technologies is a factor that we cannot ignore. Data breach cases demonstrate the complexities associated with the disclosure of PI, healthcare, financial disclosure. However, one important outcome is we are continually failing to learn from our past. And this very event has led to an increased amount of data breach cases occurring. Thank you, Katina, for your time.
Thank you so much, David. I know you have a long list of bibliography there, which is awesome. And I want to just thank you for the incredible energy you've shown throughout the last period of time while we've been engaged in this research alongside Dr. Robert Abbas and also Dr. Mark Friedman. You've really carried this. And I know as every data breach has presented itself, you've gone in and analyzed it. Interesting that we started with this notion of the regulation in your presentation, the dimensions of a health regulation in HIPAA, the financial regulation, and of course the Stored Data Act in the telecommunications space. You know, three of the most important interrelated areas: health, finance, and telecoms, which are really critical infrastructure when we look at it. And it's like an assault on this critical infrastructure, particularly with knowledge of who's interacting, who's doing what, and that personal identifiable information, which has become so attractive on the dark web. You know, do you think, if we move to Q&A style for a moment, do you think that consumers are aware of what's happening with their data and the data trails they're leaving behind and the potential for hacking and how that could be misused?
I definitely think that they're not aware of the potential of the data being misused. First and foremost, I would like to say most end users are probably not aware that they're using cloud services, that they're, that they're using just this, just an online site. But the ramification of them using that online site, they're definitely not aware.
On that note, this lack of awareness, do you think there's apathy in terms of consumers? I mean, you mentioned the Facebook breach, huge. I think you said 500 million.
Yes.
Okay. Is there an apathy, like everything is open, they're web scraping anyway, who cares what's private, what's public? But in actual fact, what's going on in that process? Do you think people are concerned when there is a breach of that size, or it's just another breach, let's move on, who cares, we're not going to get any compensation from it, that's just life if you're living on the internet? What do you think is going on there?
I believe from an end user perspective, they're definitely not aware of what's occurring around them. Regarding your question with end users being compensated, that there will be a long haul in trying to solve the problem. But the important takeaway piece here is to understand that data breaches will continue to occur. The increased use, and we've seen it over the last 12 months, especially with COVID, there has been an exponential amount of data breaches. And it's basically been, you're going to use a cloud service, you're going to get hacked. So, yeah, so the takeaway piece is that consumers need to be aware. They need to be aware that the information has been disclosed. But another important thing is that we need to think about what actually happens to that data once it's been disclosed. Is there potential for misuse of that data? And can that data come back and actually haunt the user years later? So we've seen the recent Facebook data breach that actually occurred in 2019, and it's been resurfaced again on the dark web. So you can't run away from your past, and once it's been released, it will be there. So the takeaway piece is, once again, are cyber criminals actually building up data banks? Are they profiling you to a point that they actually know more about you than you know about yourself? So I would say, yes, it's important that end users are notified promptly. Yes, it might not solve the problem, but it needs to, as a whole, we need to advance in the notification space.
Do you think that consumers are ever going to be compensated Do you think that large companies are ever going to be penalized, big sums for these data breaches? It's happened to you again for the third time. It's more than $3 million in the context of Australia. It's a huge data breach, this many end users, compensate them. You're penalized. Are we seeing any of that trend occur?
We've seen a lot has occurred in the EU with the General Data Protection Regulation. We've seen British Airways, they got hacked in 2018. They were originally going to be penalised more than $130 million, but because of COVID, they were downgraded to, I believe, 18 million. So they've kind of got a get out of jail free card. Compensation will not solve the problem. Accountability does, to a better point. But as seen in my PhD thesis, is that we can always go to the court or the courts, but it won't solve the problem. We are constantly reinventing the wheel, and once there's been a major outcome, I'm sure that another breach will come in its place, and somehow will be stopped by, the massive roadblocks associated with legal fees and legal costs. So compensation, I believe, does not solve the problem. Accountability has a greater chance of solving the problem, but we have to face the fact that this is an ever-growing and a continuously revolving situation.
This notion, that the courts can't solve all the problems and things drag on. I know early on in your research, we published a paper. It was a very good lit review and it has been cited by a lot of people. I think it was in 2015, but you had begun to study intricately, what was happening in the courts. The Sony PlayStation example was a good one, where we tracked the timeline, from the first day that we found out about the data breach, the known date of the data breach, and then its play in the courts. And I was shocked. I think it must have been like 5-6 years later, we were like, it's still in the courts. Tell us about what you've observed as you've looked at the court cases. Let's look at the Sony one, just as an example, or any of them. How long is this gestation period of, put it to the court, drag it through the court, people screaming, we need to be remunerated, look, class action lawsuit, blah, blah, blah. And in the end, tell us what happens.
That's a fascinating question. In regard to the Sony PlayStation data breach, the legal course did take numerous years. And an important thing to note here is that how deep are your pockets? That is, I can say that because I've read it, I've seen it firsthand. So end users are constrained. Large corporations, large multinational corporations have a much deeper pocket, and they're willing to protect themselves in the courts. Now, what we have seen a progress has been a glacial approach, a glacial outcome, is that there have been numerous court sightings within the Sony class action lawsuit that has somewhat hindered the progress of an outcome. So I'm more than keen to say that it comes down to financials. It comes down to how willing are the end users to actually take it to the large corporations. We've seen it in the media as well. We've seen a large amount of stakeholders being represented in the media, basically saying that we do need to do better. but holistically, there's each stakeholder needs to focus on what needs to happen, and we do need better data protection. We do need better notification processes. That's not going to solve our problem, but it will increase end user being notified in a time that they can protect themselves.
I have a final comment that I want you to respond to, and that is, you know, this emphasis that you have in your work and the outcomes that you've found from the studies you've conducted and the analysis, the deep analysis of the legal case studies in that, like, case law, that dense case law, and all of these databases you went through over so many years, over and over again. This notion of human and social dimensions and the technical dimension, and this notion of regulation in the environment and the suitability of the socio-technical theory. I know the work of Dr. Roba Abbas was highly influential here to your work and mine, and she looked at location-based services back in 2009-ish, and those kinds of direct and indirect stakeholders. But you found very similar things in a completely different application area. She looked at location-based services, you looked at cloud computing. How was it? You know, even in the Sony PlayStation, you identified human/social and technical issues and others. You know, it was just human error. I think it was Equifax. Tell us about the importance of that theory, and tell us about what you found were the big, like, mistakes by these big companies.
The mistakes are predominantly from employees. So like, one of the main outcomes that I got from my thesis, from my research thesis, was that corporations undervalue human interaction with the technology. So they undervalue the urgency to train and the urgency to educate employees, the users of that system internally, that they need to be educated and to be able to identify potential ways of hackers, either through social engineering attacks, or through masquerading attacks, etc., how to be able to reduce the potential for a data breach. And the influence between the human and the technology plays a very important process here. You know, we've seen in the eBay, in the 2014 eBay data breach, we had external users, actual end users of eBay, telling eBay themselves, telling eBay that they have a vulnerability, and the corporation ignored it. So we can say that it's vitally important to focus as a social technical system within the corporation, but then to also extend that and to incorporate external end users into the design process. That was a fascinating outcome in that particular breach. But there was an important citation in my literature that basically said Wall Street does not give you a reward for protecting your data. It gives you a reward for making more money, more financial for your shareholders. So that was probably one of my most influential studies that I've come across that actually said it outright. You can reward a business by giving them more shareholder value. At the same time, Wall Street's not going to give you anything just by protecting your end user data. So that was, I can probably say that was probably one of the most influential studies that I came across.
Well, I definitely have heard similar, you know, it's a great quote, isn't it, to take away and share with others learning about the space. But I do remember a big talk by someone high up in one of Australia's biggest banks talking about risk appetite and talking about, you know, large organizations really only care when their brand takes a big hit in the media, and how much the role of the media can support accountability, you know, almost like a name and shame kinds of solutions in an industry reg, or federal regulation or state-based regulation is not going to cut it. What will? But this thing of risk appetite, you know, I'll keep going, make more money until someone says stop, and until the penalties become so big that I have to respond to the actual laws that are forming, or the actual authority. You know, who is the authority in cloud computing data breaches? Is there a governing body? You know, in your eyes, is it just between the regulator and the organization? And who is the regulator? Is there a regulator everywhere?
Yeah, that's an important question, and it's very complex to a degree that it's based on boundaries. It's based on jurisdictions. We've seen massive progress, as I said, during the presentation about the EU. The EU has set such a large, important precedents that corporations outside of the EU have to adhere to. So while, for example, Australia might have a somewhat appropriate approach, the EU actually forces Australian-based companies to better protect EU users. And the same goes to the US. We've seen numerous states trying to enhance their regulatory approaches in data breach applications. Yeah, so we've seen, I would say, jurisdictions place an emphasis on other jurisdictions to enhance regulation. Yeah.
Well, David, I know this Q&A session could go on and on. It's been wonderful today to listen to both your presentations to the conference at UEMGreen, and I thank the folk there in India for inviting that paper and including it in their proceedings. Thank you for an extended presentation, taking time out from your busy day. You know, you work in this space, and you're also right at the end stage of submitting your final changes to your thesis and getting that doctor before your name. We're so proud of you, and we look forward to more conversations. I know we're going to have dozens of these conversations as you begin to publish big portions of the thesis in the year to come. So thank you very much.
Thank you. Thank you very much for allowing me to present more than just a conference paper here, to give an insight into my research, but to give insight to other important areas of this topic. So thank you very much.
Well, David Kolevski of University of Wollongong, congrats, and looking forward to our next conversation.
Thank you.
Thank you.
Bye for now.